You ever wonder what happens when the harm someone survived isn't a single violent moment, but something that happened quietly, inside a hospital or an institution, wrapped in paperwork and silence? That's the reality for survivors of forced sterilization and reproductive rights abuses abroad, and immigration law has a surprisingly specific lane for exactly this kind of pain. Here's the twist most people don't expect. The United States doesn't just consider physical injuries when reviewing asylum or humanitarian claims, it also weighs violations of bodily autonomy as a form of persecution. Think about it like this. If a government or an institution abroad performed procedures on someone without real informed consent, that can qualify as persecution based on membership in a particular social group, which is one of the 5 protected categories under asylum law. Now, let's slow down and explain what particular social group even means, because it sounds like legal jargon soup. Basically, it means people who share a characteristic they either cannot change or should not be forced to change, and courts have recognized reproductive coercion survivors as fitting that mold in certain cases. Here's where the plot thickens. You don't always need to prove the abuse happened at the hands of the government directly, because persecution can also come from an institution the government failed to control or actively enabled. Let's talk timing, because timing trips people up constantly. Asylum generally requires filing within 1 year of arriving in the United States, but there are exceptions for changed or extraordinary circumstances, and trauma-related delays can sometimes qualify. If asylum's timeline feels impossible, there's another path worth knowing. The Convention Against Torture, often shortened to CAT, has no filing deadline and can protect someone from being sent back to a country where they'd likely face torture again. Let's bust a myth right now, because this one spreads like wildfire. People assume you need visible scars or a police report to be believed, but immigration judges are trained to weigh testimony, medical evaluations, and country condition reports together. Speaking of evidence, medical and psychological documentation matters more than people realize. A forensic evaluation from a doctor familiar with trauma can translate a survivor's experience into the kind of clinical language judges expect to see. Country condition reports are basically the receipts of the immigration world. These reports, often compiled by human rights organizations and even the State Department, help prove that reproductive abuses were happening systemically, not just as an isolated, unlucky incident. Here's a human truth nobody puts on a pamphlet. Many survivors don't talk about what happened for years, sometimes decades, because shame gets weaponized just as effectively as the abuse itself. Let's zoom out to the bigger historical picture for a second, because this isn't new. Forced sterilization programs have existed in multiple countries and time periods, sometimes targeting people based on disability, poverty, ethnicity, or incarceration status, which is exactly why international law eventually caught up and named this a distinct category of harm. Now, here's the part that actually determines whether a case succeeds or stalls. Working with an immigration attorney who specifically understands trauma-informed interviewing and gender-based persecution claims can be the difference between a rejected filing and a life-changing approval. If you're wondering whether your story counts, here's the honest answer. There is no perfect story that guarantees approval, but there is a clear legal framework, and preparation with the right documentation dramatically improves your odds. So if any of this hit close to home, or you just want to understand your options without the legal fog, you want to learn more about our company? Check out our links in the description.